Well, good afternoon, everyone. Welcome to the IPA Power Hour on prevailing wage and project labor agreements for renewable energy projects. My name is Megha Hamal. I am the Chief Strategy and Communications Officer for the Illinois Power Agency, and I will be responsible for hosting the presentation today. I would also want to do a quick shout out to IPA Communications Manager Brian Hepner, who will be supporting me on the logistics. So thank you, Brian. To get started, let's go over some housekeeping items. To reduce any background noise, all participants are muted upon entry. We will be taking questions towards the end, so please feel free to submit questions by using the chat feature on the Zoom panel at any time during the webinar. We have submitted this webinar for CLE credits. We are waiting for approval on the CLE credits from the MCLE board. If you are an attorney seeking CLE credit, please use the Google form that Brian will be dropping in the chat to record your name and the ARDC number. Once we get the CLE approval from the MCLE board, we will submit this form to them, and you will be receiving the CLE credits for this webinar. Today's session is being recorded. A copy of the recorded session and a copy of the PowerPoint presentation will be available on the IPA website under About IPA Events. A couple of points that I would like to emphasize before we begin. Today's webinar is for general education purpose only and does not represent a legal representation or statement of policy by the IPA or its staff. This 60-minute webinar will explore Prevailing Wage and Project Labor Act in Illinois, but it will also look into prevailing wage and project labor agreements for renewable energy projects that are participating in the IPA renewable energy programs and procurements. Those that are new to our Power Hour webinar series, these are educational and informative presentation on a wide range of energy and clean energy topics and emerging themes. We started the webinar series back in 2021. To date, the agency has hosted more than 31 Power Hour webinars and invited energy thought leaders and experts locally and nationally. If you want to take a look at our webinars from the past, there is a link that we've dropped in the presentation that will take you to an archive of all our 31 webinars. Those who are new to our agency, we are the Illinois Power Agency. We are an independent state agency created in 2007. We are responsible for the procurement, electricity procurement for customers of electric utilities. We do this by developing the annual electricity procurement plan. We also support the Illinois Renewable Portfolio Standard, which is state policy that is implemented to increase the development of renewables in the state. And we do that through the development and implementation of long-term renewable resources procurement plan every other year. We also conduct competitive procurements for utility scale solar, wind, and brownfield photovoltaic projects. And we also oversee the two solar incentive programs, Illinois Shines and Illinois Solar for All. With that, I would like to welcome our speakers for today. Our first speaker of the session is Jane Flanagan, Director of the Illinois Department of Labor. Prior to her appointment, Jane served as Deputy General Counsel and Deputy Compliance Officer in the Office of the Illinois Governor, where she provided counsel on legal and regulatory matters across a portfolio of state agencies with a focus on labor standards enforcement and workforce training. As an expert in labor and employment standards, Jane will provide a detailed outline on prevailing wage law and project labor agreement in Illinois. Welcome, Jane, and thank you so much for joining our webinar.
Thank you for having me.
Yeah, of course. We're really delighted that you're here. Our second speaker for the session is our very own IPA Chief Legal Counsel, Kelly Turner. At the IPA, Kelly oversees a variety of legal and policy responsibilities. Prior to joining the IPA, Kelly worked as a senior attorney for the Citizens Utility Board and as a trial attorney in the Office of General Counsel at the Illinois Commerce Commission. With her legal expertise in energy policy, Kelly will be leading the discussion on prevailing wage requirements and project labor agreement for IPA renewable energy projects. Welcome, Kelly. Now, I would like to welcome our first speaker, Director Flanagan from the Illinois Department of Labor, to kick off the presentation.
Thank you so much. And hello, everyone. Can everyone hear me okay? Do we have any tech issues before I get started?
I hear you, thanks.
Yeah.
Great. So hi, my name is Jane Flanagan. I direct the Illinois Department of Labor. I am not an energy expert in any way. I am here basically to kind of ground us in what is prevailing wage, what is this term PLAs, et cetera. So next slide. So my hope is that we'll do just a tiny background on the Department of Labor and what we do, get into kind of an overview of the prevailing wage law generally and its history, and then touch on project labor agreements before turning it over to Kelly to really talk about those concepts within the IPA and renewable energy space. Next slide. So at the Department of Labor, our mission is to protect and promote the wages, welfare, working conditions, and safety of Illinois workers by enforcing state labor and employment laws. We also provide compliance assistance to employers, and we aim to increase public awareness of workplace protections, partner with community organizations that are supporting workers on the ground and as well as small employers. So that's our mission. Next slide. We enforce about 25 at this point, wage, hour, and other labor standards. These are sort of the ones you would traditionally think about: the minimum wage law, the child labor law, the right to equal pay for equal work, the right to meal and rest breaks. We also enforce public sector occupational safety and health. So think about fire departments, roads, transportation. We have both occupational safety standards on these projects. We have 4 labor enforcement divisions. And as a fun fact, we also inspect carnival and amusement attractions throughout the state. So I always like to give this plug. If you're going to Six Flags or you're going to Traveling Carnival, look for the little DOL inspection sticker before your kids get on that ride. Make sure it's been inspected. Next slide. So the department, among those other many duties, also enforces the Prevailing Wage Act. So the Prevailing Wage Act requires that contractors and subcontractors on covered public works projects, we'll talk about what that term means in a minute, pay no less than the general prevailing rate of wages, that's defined as hourly cash wages plus benefits, for work of a similar character in the locality where it is performed. So let's talk about what that means. Next slide. So first, let's talk public works. What is a public works project? So most traditionally, prevailing wage requirements apply when government builds something. Think a road, a bridge, a library, some other public building. When government uses public dollars to build a public project, it can set terms and conditions on the project, including payment of prevailing wages. It gets a little more complicated when there are other forms of projects or the funding is more creative. But prevailing wage generally also applies to public projects that are financed with, things like capital funds, bonds, grants, etc., loans. And through the CEJA legislation, as we'll talk about, renewable energy projects in Illinois are largely required to also pay prevailing wage pursuant to the Power Agency Act legislation. And then just to note a recent change, construction projects performed by third parties contracted by a utility company are also required to pay prevailing wages. So, when ComEd does the project directly with its own employees, it is not covered. But when they contract out with a third party contractor, that is covered for prevailing Next slide. So what are prevailing wages? And many of you, I'm sure, are very familiar, but for those of you who aren't, when we talk about the minimum wage, right, the minimum wage is a single number statewide. It's $14 an hour right now. Prevailing wages, though, are really the wages that prevail in a place for a certain type of work. So the department actually surveys trade classifications every month in June, and we establish the rates for, journeyman electrician in Cook County. There is a number that is surveyed that will be the prevailing rate for that craft, that trade, in that location. And those rates, those surveyed rates, as I said, are surveyed annually. They're available on the department's website to be, you could look them up by trade and by county. And that's the base. So when we talk about prevailing wages, it's not a single number. It's a complex schedule of wages by trade and craft. After that survey process in June, we publish those on our website in July, as I mentioned, and then the trade groups have an opportunity to say, no, this survey is wrong for this reason, or look at this, or this classification is wrong. And those matters can be worked out through administrative hearing at the department in what's called Section 9. Next slide. So in addition to this obligation to ascertain and post prevailing wages through the survey process, the Department of Labor also does a few other things in regards to prevailing wage enforcement. We collect through a portal, an electronic portal, certified transcripts of payroll. So on prevailing wage covered projects, contractors are required to report their payroll to document what they have paid in the preceding pay period to all workers on the project. They upload those certified transcript of payrolls in the department's portal, and we store those. We use them for a couple of different reasons. One, to issue statutorily required workforce data reporting. So the Illinois General Assembly is very interested in who is actually doing work on public works construction projects. What are the demographics of that workforce? Where are they coming from? Are they coming from out of state? Are they coming from within the state? And so by aggregating the data in those certified transcript payrolls, the department produces reports annually for the General Assembly around these workforce data reporting questions. And we also use it because we enforce the Prevailing Wage Act. So when we get a complaint that prevailing wage has not been paid on a particular project, a first step can be to go back and look at that certified transcript of payroll and look at least on paper, what was reported to have been paid. Next slide. Certified transcript of payroll. I think I got ahead of myself here. Again, that's that electronic reporting system of payrolls that have been paid. And if you go to the next slide, I believe I have a next slide. Yeah, so this will show you on the department's website, there's an actual interface. Anyone can create a login to look at those certified transcript of payrolls, to upload, etc. They can be downloaded in PDF form from our website. Next slide. And as I mentioned, we then use those to produce various reports for the General Assembly and the governor, including for purposes of this webinar. We do a clean energy project report, which we send to the Illinois Power Agency each year. Next slide. And we enforce the Prevailing Wage Act largely through a complaint process. A third party, a union, a worker can all file complaints with our office. We'll do an investigation, look at the certified payroll records, talk to workers. Typically what happens is that violators may pay essentially the difference between whatever the wage rate paid was and the prevailing wage rate on the project. The majority of these investigations are resolved informally at the department of level. However, if they can't be resolved at that level, we send it to the Attorney General's office, and the Attorney General represents the department in court in securing penalties, sometimes up to punitive damages, and if a contractor has multiple violations, that can lead to debarment from future state work. So that's sort of prevailing wage. Let's shift for a minute then into project labor agreements, because these terms are often used together or interchangeably, but they really are different. So a project labor agreement is a form of a pre-hire collective bargaining agreement. It covers all terms and conditions of employment on a particular project. So again, while prevailing wage is a law, is a statutory sort of floor, a project labor agreement is a contractual agreement, typically between signatory unions and a contractor on a particular project. Contractors who win a bid typically sign a letter of assent to the PLA. And contractors do not, under the Illinois Project Labor Agreement Act, contractors don't have to be unionized. They don't have to be union signatory contractors, but they do have to agree to comply with the term of the CBAs, the signatory unions, established through that project labor agreement for the life of that particular project, not the project itself. Next slide. I'm not going to read this. This is the text of the Illinois Project Labor Agreement Act, but it does give you kind of an overview of the components that a project labor agreement typically include. Project labor agreements typically include a guarantee against a strike or a lockout or other kind of similar labor disruptions or actions. They ensure sort of reliable, steady supply of labor for a project. They set up procedures for resolving disputes under that project. So again, rather than coming to us as a government agency to enforce those terms, those terms are established through the PLA to be resolved between the parties contractually. Anything else there? They often set goals also through a project labor agreement for inclusion of a certain number of for what the workforce demographics are going to look like on the project. That might include what percentage of women or people of color are doing work on that project, etc. And they can really include other terms so long as the parties agree to them. Next slide. Project labor agreements traditionally are used for kind of these large scale complex projects where there is a need for technical or safety expertise, where there's a need for cost control, predictable costs over a period of time. So for those of you who are lawyers, the kind of a seminal case on this is what's known as the Boston Harbor case, right? The Boston Harbor project is this incredibly complex infrastructure project with the related big dig. It's sort of held up as an example of that kind of complex, lengthy project in which a project labor agreement might be used. And it's enforced, again, pursuant to the terms set forth in the project labor agreement itself. So I mention this again because sometimes trades come to us and say we have this issue up with the PLA. That's not something the department can enforce. So I think that that kind of covers my piece. Kelly, I'm happy to turn it to you to kind of talk about how this works within the context of renewable energy projects, and then hopefully we'll have time for questions at the end or anything I covered too quick.
Great. Thanks so much, Jane. That is really helpful background and context for what we're going to be talking about now, which is specifically how prevailing wage requirements and project labor agreement requirements tie into the IPA's renewable energy projects. So Micah, if you could go on to the next slide. This is, we covered that last slide again. I do want to talk briefly about the long-term renewable resources procurement plan. If you can go on to the next slide, please. The prevailing wage and project labor requirements that we are going to be talking about today apply to programs and procurements designed to incentivize renewable energy projects under our long-term plan. So I just have some background here about the long-term plan. The long-term plan is revised by the agency every 2 years. Most recently, the Illinois Commerce Commission approved our 2024 plan in February. And this plan will govern the details of our renewable programs and competitive procurements for RECs from utility scale projects over the course of the delivery year that begins June 1st, 2024 through the next 2 delivery years, so ending May 31st, 2026. The IPA incentivizes the development of new wind and solar projects and also some hydropower projects through competitive procurements for RECs. So those are individual procurement events that we hold twice a year for the purchase of RECs. And then we also run the Illinois Solar for All program, which focuses on income eligible communities and individuals, and the Illinois Shines program, which is available more broadly statewide to incentivize the development of new solar projects that are below 5 megawatts. And then we also administer a self-direct program where large customers can receive an offset on their utility bill for charges if they procure RECs on their own. And so we'll talk about how these labor requirements apply to all of these different programs and procurements. Next slide, please. Thank you. We're going to start with prevailing wage requirements under the IPA Act and how they apply to all of these different project types. So there's several different ways that the prevailing wage applies under the IPA Act. Of course, Jane already talked about the Prevailing Wage Act itself, and the public works definition does include now renewable energy projects that are required to pay the prevailing wage pursuant to the IPA Act. Well, what are those provisions of the IPA Act under which developers are required to pay prevailing wage? Under 175C, utility scale wind and solar, hydropower, and brownfield sited solar projects that participate in our competitive REC procurement events are all required to pay prevailing wage. And then projects incentivized under the Illinois Shines program, with certain exceptions, which I'll talk about a little bit later, are also required to pay prevailing wage. This was enacted under CEJA. More recently, changes to Section 156 of the IPA Act has also made prevailing wage requirements applicable to the Illinois Solar for All program. Again, with some exceptions, which we will talk about on later slides. And then under 175C1R, which details the requirements of the self-direct RPS compliance program, explains that projects that are participating in the self-direct program must also comply with the provisions of 175C1Q. So those projects are also required to be built with prevailing wage. Next slide, please. Thank you. So what exactly does that mean? Projects that are required to pay the prevailing wage: utility scale wind, utility scale solar, brownfield site photovoltaics, projects participating in the self-direct renewable portfolio standard compliance program, that self-direct program, and Illinois Shines. And those have been in effect since September 15th, 2021, when CEJA passed. And projects incentivized under Solar for All, those requirements were effective June 30th of last year under a new law that was passed post CEJA to bring those requirements in to the Solar for All Next page, please. We do have, as I mentioned a couple slides ago, exceptions to the requirement to pay prevailing wage in certain circumstances. In the Illinois Shines and Illinois Solar for All programs, projects that serve residential buildings, whether they're single family or multifamily, are not required to be built with prevailing wage. Also, projects under 100 kilowatts that serve houses of worship are exempt. And for the Illinois Shines program specifically, the statute tells us that any project participating in the large distributed generation category prior to CEJA that was waitlisted at that point is also not required to pay prevailing wage. Because the requirements for prevailing wage did not exist in the program prior to September 15th of 2021 when CEJA was enacted, the agency also does not require demonstration that prevailing wage was paid on projects constructed prior to that date. So there is no requirement that a project must apply to the Illinois Shines program prior to being built. So we do see sometimes some projects that have previously been constructed apply to the program. In this case, we do require a demonstration that the project was constructed prior to CEJA, but we do not require a demonstration that prevailing wage was paid in those cases. Also, Solar for All projects that went under contract prior to June 30th, 2023. The statute specifically tells us in the case of Solar for All that it has to do with the date of the contract. So any project under contract prior to the enactment of that statute does not have to pay prevailing wage. And then self-direct projects with a REC contract that was entered into prior to the effective date of CEJA as well do not have to be constructed with prevailing wage. Next slide. The IPA, prior to finalizing project applications and verifying that projects have been built in compliance with prevailing wage requirements under Illinois Shines and Illinois Solar for All, we do confirm as best we can the compliance with these requirements. There is a two-part application for both Illinois Shines and Illinois Solar for All. At the beginning of that application, approved vendors who are participating in the program must complete an attestation that they understand that the project is subject to prevailing wage requirements. We make sure that this is a part of the application and that the applicant specifically attests to the fact that they understand that that is a requirement for the project before the initial application is submitted, and they are aware that the project will not be verified at the end, and therefore incentives for RECs will not be paid if there is not a demonstration that prevailing wage requirements have been met. Approved vendors, their contractors and subcontractors are all required to meet all of the provisions of the prevailing wage law that Jane just went through. What we require on our end to demonstrate that those requirements have been met is that copies of those certified transcripts of payroll that were submitted to EIDL are also provided to us with the Part 2 application. Those CTPs are all publicly available in the EIDL database, as Jane discussed, but we actually ask for copies to be provided with the Part 2 application, and if no CTPs are submitted, the project cannot be Part 2 approved. Next slide, please. For competitively bid REC contracts that participate in our procurement events for index rec, the commitment to pay prevailing wage and meet all other applicable labor requirements, as we'll discuss later on. That's made during the bidding process. There are projects that may bid in to these procurement events that are not located in Illinois. There's certain adjacent state criteria, and if projects meet those adjacent state criteria, they can bid in and potentially win a rec contract through the process of our procurement. Recognizing the fact that some of our neighboring states do not have prevailing wage statutes, we make those out-of-state projects agree to pay the Davis-Bacon wages that would apply in the community where the project is cited. For the self-direct program, the application process works differently than it does for the Solar for All program or the Illinois Shines program. In this case, applicants are submitting their application to the IPA after the project has already been completely built and energized and is scheduled to start delivering RECs in that delivery year. So the applications here have to demonstrate that the projects were built in compliance with prevailing wage. And so we have a backwards looking review on this one. And if there is no demonstration of prevailing wage, the project is unable to participate in the self-direct program. Next slide, please. Okay, those are all the requirements related to the prevailing wage requirements. Certain projects also are required to enter into a project labor agreement, as well as pay prevailing wage. So we're going to talk about those projects now and then how this process works for those. So 175C1Q also lays out the project labor agreement requirements for certain projects participating in IPA incentive programs. Utility scale wind and solar projects, brownfield site solar projects must all be built with a project labor agreement. This, however, is not applicable to hydropower. It's just kind of a unique aspect of the law that hydropower got pulled in on prevailing wage, but not on project labor agreements. And it's important to note that these project labor agreement requirements are in addition to the prevailing wage requirements. It's my understanding that generally project labor agreements, we do most often see that a wage rate that is equal to or higher than the prevailing wage is paid. However, it's important to note that those prevailing wage requirements still exist for these projects, and it's not just it's not just a project labor agreement that applies to these larger projects. Next slide, please. So under 175C1Q, new utility scale wind and solar and brownfield site photovoltaic projects have to be built by general contractors that enter into a project labor agreement. The IPA Act requires that all project labor agreements are consistent with the Illinois Project Labor Agreements Act, and it defines what that looks like in the IPA Act. Next slide, please. I want to go back to, I edited a slide and I'm not sure if it's one in the front or the one that we just passed a couple slides back, but if you can go back 2 slides actually. Project labor agreements are also required under 175C1R for projects that are participating in the self-direct program. The statute tells us that any project participating in the self-direct program must meet the requirements of Q. And so that includes paying prevailing wage and having a project labor agreement in place. So I just want to make sure that that doesn't get lost here as we're talking about project labor agreements, that customers participating in the self-direct program must be able to demonstrate that a project labor agreement was in place for that project to be eligible to participate. We can skip back ahead. Thank you. So the projects that require project labor agreements are competitively bid rec contracts. The bidder has to confirm their commitment in the bidding process for those competitively procured projects, or the recs from the competitively procured projects. The rec contract coming out of those procurement events requires the project owner to submit the executed project labor agreement to the director of the IPA within the later of these 3 items here. We recognize that a project may be bidding into our procurement at different stages of construction, right? And so if it's already under construction and there's a project labor agreement in place, or if construction is not going to start for some time in the future, these are the different triggers within the rec contract under which they would have to provide a copy of the project labor agreement to the director of the IPA. For a project that is participating in the self-direct program, that will be submitted to the IPA with the application. And then the IPA on our end confirms that the submitted project labor agreement meets the requirements of the IPA Act and the Project Labor Agreement Act, and we provide a confirmation of that to the project owner. Next slide. Here we go. So projects participating in the self-direct program, as I said, are required to have a project labor agreement in place as well. This is only applicable to projects where the rec contract was entered into after the effective date of CEJA. So if a customer has a rec contract or a bundled contract for recs and energy that they entered into prior to CEJA, that project does not have to be built paying prevailing wage or with a project labor agreement. And again, we would go through the same process of reviewing the application, just like we do for prevailing wage, to ensure that the project was built under a PLA. We ask for copies of the PLA with the application. Next slide, please. All right, that was all that I had. I think we have time now for questions and answers. A few minutes earlier, I think, than we maybe thought we would have, but happy to take any questions. Or Mega, not sure if you have anything that you wanted us to dive into deeper.
I am looking at the chat window, Kelly, and I'm not seeing any questions. But if anybody wants to go on mute, we can definitely unmute you as well. Just let us know, and you can ask that question that way, or just submit the question in the chat. While we are waiting for any questions, if there's anything else, Jane and Kelly, you would like to talk about, we can do that right now as we are waiting on any questions. Okay, we are still waiting. It's almost 12:40. I mean, if we don't have any questions, we can also end the webinar quickly. If you do have any questions, there's other way of getting hold of our speakers. It is through emailing them. So here are the contact information for our speakers, Director Flanagan and Kelly. Oh, speaking of a question, we just got one, so I'm just gonna go ahead and read it out loud. For renewable energy projects, can you give any examples of types of work that wouldn't be covered under a PLA? Transportation of equipment to the site, for example. And this is a question from Amy.
Yeah, Amy, I don't know that this would be different for a renewable energy project than it would be for any other type of project that um, has to be covered by a PLA. I think in terms of what the IPA is looking at, we're looking at the requirements of the Project Labor Agreement Act and what that covers, what that requires to be covered. I believe, and I don't, you know what, I don't want to say anything that I think is incorrect on this video because I know that we're posting it, but you know, so we're going to be looking to the guidance from the Project Labor Agreement Act and in the IPA Act for what must be covered and what must not be covered.
Okay, we got another question from Stefan. Stefan is asking, are PV projects that are non-utility scale, less than 5 megawatt, that are receiving REC contracts required to pay highway heavy prevailing wage rates, or would builder be the appropriate wage determination?
Thanks. I can try to take some of this. So those highway heavy rates are Davis-Bacon terms that are used under essentially the federal prevailing wage law. So we don't want to answer kind of what the federal wage rate determination would be on a federal project. I would say that in Illinois, we don't, our rates are posted by the type of trade and craft doing the work. So I would determine who's doing that work. Oh, this is heavy, state heavy equivalent in Illinois. Yeah. So we survey, like, I guess I'm having trouble. Maybe if you come off mute, but because I'm maybe having trouble interpreting the chat. I can't answer without knowing facts on the ground, kind of what the specific correct classification would be in a particular place. But I would urge you to call our staff and kind of talk through, hey, this is where we are, looking at the rates that are posted. This is the area, this is the type of work, and they can help advise like what's the right classification to use. And I can share in the chat that webpage.
Okay, that would be great. Thank you.
Okay. I think those are the only questions we've received so far. Maybe we can wait a quick minute to see if we are getting any last minute questions. If not, then we can go ahead and end the webinar early today. But let's just give it a minute to see if we can get one more question from somebody. Okay, not seeing any questions. That's fine. As you all know, this webinar is recorded, and a copy of this webinar will be posted on the IPA website. Thanks to Director Flanagan for submitting that link for Stefan's inquiry. At this point, I really want to thank our wonderful speakers for sharing some insights on the topic, and also our attendees for taking time to attend this webinar. So thank you all for joining the webinar today. If you have any questions, please reach out to Director Flanagan or Kelly at those email addresses provided in the presentation. With that, I would like to end the webinar and just want to wish everyone a happy Memorial Day weekend. I know the long weekend is coming, so hope you all have a great time. And we will see you at the next webinar in June, so stay tuned for that. Thank you.
Thank you.
Thank you. Thanks everyone for attending.